Everyone for today's webinar, the nuts and bolts of delay analysis. This is the fourth and final part of the ICDR Y&I's construction webinar series. My name is Giorgio Sassine. I'm an associate at Music Peeler in Los Angeles, and I'm also a member of the ICDR Y&I board. I'm really happy today that we have such a stellar panel who are all experts in this field. First, we are joined by Meera Wagman. Meera is a delay expert at Secretariat in New York. We are also joined by Emily Elliot. Emily is a construction disputes attorney at White & Case in London. And last but not least, we are joined by Matilde Flores. Matilde is also a construction disputes attorney at Chaffetz Lindsay in New York. With this brief introduction, I would like to first set the scene.
Giorgio, make me interrupt very quickly just to, I just want to take a moment to remind people to please go to our ICDR Young and International website. You can register there. You can see the recordings for previous webinar, previous installment of this series and the previous construction series that we had. And I also want to thank our co-sponsors, the ABA Forum on Construction Law, the Society of Construction Law North America, and Y Construction, as well as everyone that has been involved in this series this year, including Zach Torres, who has been leading the charge on this. And with that, I will not take any more time. So please, Giorgio, proceed.
I appreciate it, Rafa. So as some of you may know, construction projects can be complex, with many trades working simultaneously or subsequent to each other. The project starts with the owner. Typically, the owner will contract with the designer to design the project according to the owner's specifications. The owner will also contract with the prime contractor to construct the project according to the design, and may subcontract out specific parts of the work to subcontractors, say for mechanical, electrical, or plumbing. Simple enough, not quite. Delays often arise. For example, when materials are not delivered on time, when the owner changes the specifications in the middle of the design, when the designer has to make revisions to the design, or when the project is not constructed according to the design. In such situations, delay experts may need to be called in to determine the extent of the delay and what impact it has on subsequent work. And with so many entities involved on a complex construction project, attorneys may be called in to argue over who is liable for the delay. So with that brief setting of the scene, I would also like to add that at the end we'll take questions. So save your questions for the end and we'll deal with them at that time. And with that, I'll now turn it over to Meera.
Thank you, Giorgio. So I am going to walk through for a few slides to go over what we're calling Delay 101, kind of the basics about delay analysis. So why do we do a delay analysis? Well, time is money, and everybody cares about money. So delay analyses are really used to help all the parties that Giorgio just talked about, and really ultimately to help the trier of fact, whether it's a judge or a tribunal or a project neutral, to understand what actually happened on a project, what caused delays and impacts to that project, who might be responsible for those issues, and that involves the legal team and a contractual review, and we'll talk about that a little bit later, and ultimately, who needs to pay for the delays that were caused on the project. So what a delay analysis can do is satisfy the burden of proving a causal link between a delay or impact on a project and the damages that are being sought by one party or another. Next slide, please. There are two main types of delay, excusable and compensable. Excusable and compensable delay will get you time and money for the contractor. So favored by the contractor, not favored by the owner. These are typically owner-caused delays, could be late site access, design changes, so on and so forth, things that are claimable under the contract, of course, that would entitle the contractor to extra time and additional money. Excusable non-compensable delay will get the contractor time or an extension of time to completion, but no money. These are typically in the force majeure category or third-party causes of delay. That could be floods and strikes, and usually severe weather that's outside the parameters of the contract, or government actions, for example. Then you have non-excusable and non-compensable delay, again, favored by the owner, not so much by the contractors. You'll get no time and no money under this ruling of delay. And those are typically the delays caused by the claimant or the contractor, inadequate manpower, defective work, failure to properly meet planned progress. Those are some examples, or equipment breakdowns as well. Those are some examples of contractor-caused delays that they would be on the hook for the time and the money. And then there's concurrent delay, and we're going to have a whole separate portion later in this panel on concurrent delay. But concurrent delays are two separate delays caused by two separate parties, both impacting the critical path. And I say at the same time, and we'll talk about that. It doesn't have to be exactly on the same dates, but they both have to be impacting the critical path in the same time period. Next slide, please. So what is a critical path? Critical path is pretty much the most important element to delay analysis. Only delay to a critical path is relevant to getting an extension of time or seeking compensable delay. There's an official definition listed here. For time's sake, I'm not going to read the whole thing, but essentially, in layman's terms, what a critical path is the longest path through the series or sequence of activities to get to project completion. And you have, in the beginning of a job, typically a baseline schedule that will have your as-planned critical path. That's how the project is envisioned to be executed, and what sequence of activities is driving that completion date. As you move through the project execution, that critical path in subsequent schedule updates, as progress is being achieved or not being achieved, can change. In complex projects especially, you rarely see the critical path staying as it was in the plan. It evolves over time and changes and shifts in reaction to delays and impacts that are experienced on the project. Next, please. So I want to take a minute to just go over the basics of reading a Gantt chart, what it looks like. So this is an excerpt out of Primavera P6. What you see on the right is kind of the Gantt chart portion. Those are the activity bars. In this excerpt, they are summarized up. So these summary bars contain thousands of activities. The time scale is at the top. The vertical blue line is what we call the data date or the status date. The blue bars on the left of that line represent the as-builted activities, completed activities. And the bars on the right in green or red represent the remaining forecasted activities to completion, green being non-critical and red signifying activities on the critical path to completion at that point in time. On the left, what you see are what we call WBS or work breakdown structure categories. So when you have schedules with thousands and thousands of activities, you really need to group them into more manageable pieces. There's many different reasons for how a project may want to group these activities. But for instance, here, this example shows milestones as a summary, then you go into procurement, early works, down to design, and then construction. And then within construction, you can have subcategories. In this project, it was by area, physical area of the project. And if we go to the next slide, I've now expanded that same schedule a little bit further. And so under the construction WBS, we see we're in zone 1. Within zone 1, there are additional sub areas. And then you can drill all the way down to the white section, which is the specific activity detail. And so you can see on the right, the as-built blue activities, that signifies one singular activity. And then the red forecasted activities, which are in the schedule on the critical path. And these activities contain lots of information, but I've just shown the activity ID and name, start and finish date, and the total float. These activities are all logically linked within the program to show how the project is going to be executed and be able to track any impacts to that. This particular example is building an elevated guideway. And so these activities pertain to building the columns to support then the soffit and deck above. And you can see how the activities waterfall through, and that's all done within the P6 program. Next. So with the holidays coming up, we thought it might be fun to do a Christmas dinner example, which is just a very simple example to understand how the critical path may change over time and what it really is. And so I'm not going to go through these bullets, but if we go to the next slide, I'm just going to start talking about the actual dinner. So this is the as planned or baseline schedule for the dinner. We're going to have turkey, potatoes, parsnips, Brussels sprouts, and then at the very end, heat up the gravy, set the table, and have dinner by hour 10. we go to the arrows in black signify the sequence of how all of these dishes need to be cooked in order to be able to serve a hot dinner all at once at hour 10. This slide now shows and highlights that, of course, the turkey takes the longest to cook, and that is driving the critical path to sitting down for dinner. And your sides have what we call float. And if we go to the next slide, I'm highlighted here this kind of blank space between the non-critical vegetable activities and the critical turkey activity. That's what we call float. And float is just extra time that non-critical path activities have that they can slip before they would impact the critical path of the project. Next. So we're taking our first status at hour 3.75. So that would be our data date. And the turkey is in the oven, went in on time, and is cooking. The oven temperature is going great, and dinner is still on schedule for hour 10. Now, what happens if you forgot to put the potatoes into the oven, right? So what happens if you have an impact? Your turkey is still cooking on time, still set to come out at hour 9.5, but you forgot to put in your potatoes. So you have a delay to your start of your potatoes, but your potatoes are still going to take 3 hours to cook. So now that has shifted and has pushed the critical path into hour 11. So you have this delay to your potatoes, a shift in the critical path from the turkey to the potatoes, and an ultimate or overall impact to your dinner time of 1 hour. So this delay to getting your potatoes in will result in an hour delay to sitting down for dinner. And so that's just a very high level example about how schedules work. You contemporaneously step through each hour in this case, or each month in a project, and assess what activities are progressing well versus where impacts and delays may be impacting your critical path. Next, please. So there are different methods of delay analysis. And the Society of Construction Law, we've excerpted their summary table here, which talks about the 6 main types of delay methods that are in the industry. I'm not going to go through the table completely, but the reason why there are different methods can be based on a whole host of things. It could be what the contract requires. It could be the timing of the analysis, when the analysis is conducted. It could pertain to the size and complexity of the project. More complex projects are more suitable to use different methods than very simple projects. And in very much so, the availability of schedules and project records will help determine what method you can actually implement. A couple key points to note, though, about the types of analyses. In the colored columns, you can see green, red, and blue. So green is talking about prospective analyses. Those are forward-looking, typically done in a project that's ongoing, where you're trying to figure out what the effect of an impact will be on the schedule in real time. You're doing that in a forward-looking manner. Retrospectively, shown in blue, is the impact of the project has now completed. You know all the facts. You're sort of taking a backwards look retrospectively at what happened to try to really figure out what the delay impact was. And then the contemporaneous in the pink is saying that the critical path in those 3 methods is being assessed as you chronologically step through the project. That, in my view, is the best way in a forensic delay analysis to deal with critical path. The other point I want to make quickly is cause and effect versus affecting cause. So cause and effect is you take an impact and you find out what the likely impact or effect to the critical path would be for that specific cause of delay. That's typically, again, done in real time on projects. That does not always get you compensable delay because it is modeled or hypothetical. The effect and cause is what the SCL recommends for forensic after the fact delay analysis, because you're first assessing the critical path, and then you're looking at the project records to figure out any and all potential causes of delay to that critical path. Therefore, it's a much more independent approach than a cause and effect delay. Next, please. And I know I'm running out of time, so just categorizing those, the first 2 are kind of the modeled or hypothetical types of delay analysis, may have challenges getting compensable delay. The middle 2 are methods that are really based on the schedule updates themselves, the P6 schedules. And then the retrospective, again, especially the as-built windows method, is highly recommended for after the fact forensic delay analysis. And with that, I would like to now turn it over to Emily and Matilde, who are going to walk through some legal 101 concepts. Thank you.
That's
Thank you
great.
so much,
Thanks
Meera.
very much, Meera. So before we begin, the general objective of today's presentation is to cover only select few legal aspects concerning delay. Unfortunately, we don't have time to cover absolutely everything. But first things first, I think it's really important that we go back to basics before getting into the nitty-gritty. Can I have the next slide, please? Now, as I'm sure you're all aware, delay is one of the most common problems in construction projects. Empirical evidence suggests that most construction cases involve a delay element, and claims for an extension of time to the completion date are the most common type of dispute. Now, the time for completion is a key economic component for most construction projects, as it directly impacts multiple key parties, from project-related parties to financing and control parties, to operations and to marketing parties, as we can see here on the diagram on the screen. So what exactly is the role of the project completion date? Well, this is when the contractor transfers custody of the works and therefore the associated risks to the employer. It also starts the defects liability period, and it also might trigger the release, or at least the partial release, of bonds provided by the contractor. And it also marks the completion of the works for the purpose of ascertaining the contractor's liability for liquidated damages, which Matilde will come on to address shortly. Next slide, please. So I'd now like to run through a couple of key provisions contained in some standard form construction contracts. So for the purpose of today's presentation, we'll largely be focused on provisions contained in the FIDIC standard forms, in particular the FIDIC Red Book, which is used for works predominantly designed by the employer, and the FIDIC Yellow Book, which is primarily designed by the contractor. And this is because FIDIC are the most widely used forms, and hopefully each of you in the room today will be somewhat familiar with, or will have at least heard of, the FIDIC contracts. So back to the topic at hand. There should always be a stipulated time for completion of the works within the construction contract. This may be stated as a particular date or a period of time following a certain event, for example, the commencement date. And the contractor is required to complete the works by that date. If there is no stipulated or applicable time for completion, then there's an implied obligation to complete the works within a reasonable time. Now, under common law, this is a principle known as time at large. Now, the practical effect of this is that the contractor will be protected from a claim by the employer for liquidated damages. And again, Matilde will come on to address this topic shortly. Next slide, please. Now moving on to progress of the work itself. Obviously, continued monitoring of the progress of the works is extremely important in order to detect and address any potential problems as early as possible. In fact, the 2017 FIDIC Red and Yellow Books introduced an important new provision to reflect this. So subclause 8.4 now provides for an advance warning mechanism, which requires each party to advise the other in advance of any known or probable future events, which may A, adversely affect the work of the contractor's personnel, B, adversely affect the performance of the works when completed, C, increase the contract price, and or D, delay the execution of the work or a section. So this is a really effective tool in minimizing and mitigating claims and disputes, as mitigation and acceleration measures can be put into place to minimize the impact of any such events. So what exactly is a known or probable future event, you might be asking yourselves? Well, it's probably easiest to explain this by way of an example. So, for example, the contractor may become aware of a delay in the lead time for a specific piece of equipment, which the contractor knows is critical to the works. Certain mitigation measures may be put into place to try to mitigate any delay. For example, can this piece of equipment be swapped for another type of equipment? Or can it be supplied from elsewhere? Or can the work be resequenced in such a way that it won't have such an impact on the works, and resources can be diverted elsewhere until that material arrives, etc. So this is just one type of scenario that may cover, but of course there are many, many other scenarios. Next slide, please. Now, most contracts also require the contractor to produce and update a contract program, and this is usually referred to as the baseline program and is subject to periodic updates, usually on a monthly basis. Now, this refers to the P6 Primavera program that Meera showed us earlier. So uses of the contract program include being an organizational tool for the contractor, a tool for the employer's monitoring and supervision of the works and ascertaining any extensions of time. And it will also generally identify the critical path through the work. So it provides a linkage between activities which the contractor is required to complete in order to avoid delays to completion. So you'll see an example of subclause 8.3 of the 2017 FIDIC Red Book on the screen here, which states that the contractor shall submit a detailed program to the engineer within 28 days after receiving the notice under subclause 8.1 commencement of the works. The contractor shall also submit a revised program whenever the previous program is inconsistent with actual progress of the contractor's obligations. Each program shall include, and it goes on to list lengthy requirements, which I don't intend to read aloud in the interest of time. But what this clearly demonstrates is the weight and the importance that's attached to the contemporaneous project program. It's an incredibly important tool for the parties to rely on when monitoring progress on site. Now, in practice, unfortunately, contractors may have quite poor quality programs, either through missing logic in the program or a failure to update with real progress. So this can make it incredibly difficult to track the true critical path and the extent of any delay. Next slide, please. Next slide, please. And I'll now hand over to Matilde.
Thank you. So just very briefly to finish up this Legal 101 section, I just want to take a step back and briefly put together the concepts that both Meera and Emily have just explained to see how they actually come together in a delay dispute. So as we will see in more detail throughout this presentation, the legal issues involving a delay primarily turn on the question of entitlement. Essentially, who is responsible for the delay? Is it the employer or is it the contractor? And it basically is an allocation of risk analysis. And the starting point to assess this risk allocation is the contract itself. So the terms of the contract will provide clauses on what constitutes an employer risk event. So an event or cause of delay, which under the contract is at the risk of responsibility of the employer. So the risk that the employer assumed under the contract, or a contractor risk event on the other hand. So an event or cause of delay, which under the contract is at the risk and responsibility on the contractor. And once we have a delay in a project, the issue will focusing on categorizing that delay into one of these two buckets. And how do we go about doing that? Well, there are a couple of factors that must be assessed. One is the cause of the delay. So what caused the delay? Whether the cause was within the control of either party. This goes back to what Meera was talking about, excusable versus inexcusable delay. Whether the cause impacted the contract's critical path, and if so, by how much. And again, very generally, we will go through this in more detail throughout the presentation, but once you have a delay, there are two types of relief that is sought by either the contractor or the employer. These are, on the one hand, extension of times requested by the contractor, on the other hand, delay liquidated damages requested by the employer. So now I think Emily will talk about extension of time.
Thank you so much, Matilde and Emily, for that introduction to Legal 101. So Emily, what is an extension of time?
Well, as I'm sure you're all well aware, most construction contracts include an extension of time clause, which sets out the circumstances under which the contractor may be entitled to an extension of the time for completion. So according to the Society of Construction Law Protocol, and this is essentially the holy grail for guidance on key construction law issues related to delay and disruption, the benefit to the contractor of an extension of time is to relieve the contractor of liability for liquidated damages. Now, the benefit of an EAT for the employer is that it establishes a new contract completion date, which prevents time for completion of the works becoming at large and allows for coordination and planning of its own activities. Next slide, please. So events typically covered by EOT clauses include employer's delay. So for example, caused by the employer's breach of contract or an instruction to perform additional works, etc. It could also cover force majeure events and any unforeseen circumstances to the extent that this risk is not borne by the contractor in the contract. Now, it goes without saying that the contractor's own delay, for example, caused by its own poor productivity or its own subcontractors, results in no entitlement to an extension of time. So, for example, according to subclause 8.5 of the FIDIC Red Book, which we have here on screen, it sets out various events for which an EOT is claimable if completion is or will be delayed by any of those causes. Now, this has traditionally been understood to place the burden on a contractor to notify not only an event that has an immediate and measurable impact on the completion date, but also one which will, at some point in the future, have such an impact. Now, some uncertainty has arisen due to the interaction between the wording is or will be delayed and the requirement to give a notice of claim. Specifically, when does the clock start ticking for giving the notice? Should the contractor notify now or at some point in the future? Next slide, please. Sorry, if you could just go back one slide. Thank you. So a contractor's failure to comply with the relevant notice requirement can have significant effects depending on the wording of the contract and the applicable law in order to ascertain whether the provision operates effectively as a time bar. If a contractor's claim is deemed to be time barred, then its claim for an extension of time will fail. So, for example, as we can see here on screen, pursuant to subclause 20.2.1 of the FIDIC Red Book, a claim must be notified within 28 days after the claiming party became aware or should have become aware of the event or circumstance giving rise to the claim. The traditional view at common law is that a properly drafted notice of condition precedent will be enforceable, which can obviously have dramatic consequences for a contractor. However, the now infamous decision in Obrascon, and I don't intend to go into the facts right now because unfortunately we just don't have time, but it offered an alternative interpretation which was considered to be more lenient for contractors, as it permitted delay notifications to be deferred until a delaying event had actually impacted the progress of the works. So this could be many months after the event itself. Matilde, perhaps you'd like to say a few words on the position under civil law?
Sure. So under the civil law, in general, the parties are also expected to conform to the notification requirements and the time bars of the contract, and these provisions are generally enforced and may also bar claims altogether. In certain circumstances, however, the civil law is a little bit more lenient, and there are, in the sense that it allows the contractor to rely on certain provisions of the civil code that may allow it to adopt a more lenient approach. Clear examples of this are the provisions on equity, good faith, and even if applicable, waiver.
Thank you so much. So I think we want to move on to liquidated damages. So Matilde, what are liquidated damages?
Sure. So let's actually start by looking at the definition in the SCL protocol of liquidated damages, which we have on the screen. So they're defined as a fixed sum, usually per week or per day, written into the contract as being payable by the contractor in the event that the works are not completed by the contractor completion date, either original or extended. So unlike an extension of time that Emily just discussed, which purely concerned, as it says, an extension of time, an LD is actually monetary compensation. And they are the primary remedy, or sometimes and often the only remedy available for the employer in the event that the contractor fails to meet the completion date. They are assessed based on the number of days or weeks as specified under the contract, and they are a fixed and predetermined sum, determined at the outset at the time the contract is executed. And there is typically a cap in the amount of liquidated damages that the employer is able to recover, and it's usually assessed as a percentage of the contract price. And then if we turn to the next slide, we see that the FIDIC Red Book also has a concept of delay liquidated damages equivalent to in the event that the contractor fails to meet the contractual completion date, and this is subclause 8.8, which we have on the screen. And the logic behind liquidated damages is based on the difficulty of quantifying the actual amount of damages that a delay caused as these actually go through the project. So through the LDs, the parties agree in advance how the damages are going to be assessed in the event of a breach of the contractor in achieving the completion date.
So is there a difference between the LDs depending on the applicable law?
Yes. So in principle, courts allow for the parties to agree to liquidated damages clauses in their contract, and they respect the freedom of contract. But they nonetheless, these clauses remain subject to judicial scrutiny, and the way in which courts assess these clauses is highly dependent on the applicable law regime. So, for example, in the civil law jurisdiction, courts have the power to actually reduce the amount of liquidated damages in the clause if this is considered to be grossly excessive. And the criteria to assess this varies per jurisdiction. In addition, civil law courts have the power to increase the amount of the clause or award additional damages. And also, because liquidated damages amounts may sometimes include an extra compensatory element or may be considered to be a penalty, civil law courts do not typically evaluate the intent behind this. And in general, under the civil law, liquidated damages clauses remain enforceable even if they include this penalty aspect.
Thank you, Matilde, for that introduction to liquidated damages in the civil law perspective. Emily, is there a different perspective in the common law?
Yes, well, I think it's important to bear in mind that under common law, liquidated damages may become unenforceable if they constitute a penalty. So under English law, liquidated damages would only be unenforceable as a penalty if the sum agreed was out of all proportion to any legitimate interest of the innocent party. Additionally, liquidated damages are not recoverable by the employer where a contractor failed to perform the works within the time for completion if the employer prevented the contractor from doing so. And this is otherwise known as the prevention principle. So this was put aptly in the Roberts versus Bury Improvement Commissioner case, which states, it's a principle very well established at common law that no person can take advantage of the non-fulfillment of a condition, the performance of which has been hindered by himself. So the crux of this is really that a party should not benefit from its own wrongdoing.
Yeah, that makes sense, more of an equity argument. Matilde, are there certain ways that a party can escape the limitation of liability clause or the liquidated damages provision?
Yes. Generally, courts tend to give effect to the caps or limitations on the amount of recoverable LDs provided under the contract, but these limitations of liability will generally not be enforced in cases of gross negligence, willful misconduct, bad faith, fraud, or similar concepts. And the elements of each of these concepts need to be proved in accordance with the specific criteria under each of the applicable laws.
Thank you so much. So now that we've done extensions of time and liquidated damages, we jump to maybe one of the most exciting portions, the concurrent delay. So Meera, what happens if more than one party is at delay at the same time?
Well, many different things, and it really is, I would say, the $1 million compensable delay question. But to kick us off, I think Emily's going to walk us through the definition and what concurrent delay is, and then I'm going to take us through a few scenarios of how this concept can play out.
Great, thanks, Meera. Yeah, so I think it's really important that everyone is aware of the concept of concurrent delay when establishing arguments on causation, as this may impact the contractor's extension of time entitlement. And this is very often adopted by employers as some form of defense to a contractor's EOT claim. So again, according to the definition as set out in the SCL protocol, true concurrent delay is the occurrence of two or more delay events at the same time, one an employer risk event, the other a contractor risk event, and the effects of which are felt at the same time. For concurrent delay to exist, each of the employer risk event and the contractor risk event must be an effective cause of delay to completion, i.e., and this is really important here, the delays must both affect the critical path. So the SCL's view, and again, this is purely guidance, this is not a legal authority, is that criticality is key to concurrency. But in practice, true concurrency is very rare. And there's generally a lack of regulation as to establishing concurrency. In fact, there are actually conflicting legal authorities on what actually constitutes concurrent delay. And is this a friend or foe? You know, owners typically try to construe concurrent delay more broadly, whereas contractors tend to argue that it's a much more narrow definition of concurrent delay should apply. Now, on a recent case that I worked on, I saw an employer adopt a rather novel definition of concurrency, which took into account any so-called parallel contractor delay, no matter how far off the critical path they were. Now, this was in fact rejected as it had no legal basis, but it was essentially a but-for argument where the employer seeks to argue that but for the employer's delay risk event, the time for completion would always have been extended by a contractor risk event. Now, interestingly, the 2017 FIDIC Red Book introduced an important update in this respect, and it actually encourages parties to specify their position on the treatment of concurrent delay in the special conditions. Now, unfortunately, I don't have a snip here on the screen, but for the record, this can be found at subclause 8.5. And I'd now like to hand over to Meera, who'll tell you a bit more about concurrent delay and walk you through a practical example.
Thank you, Emily. So just a couple other points, and I think Emily touched on this, but concurrent delay, it really is a hotly debated topic. It is just viewed by many different parties in many different ways, as Emily explained. Two delays that happen at the same time do not necessarily constitute concurrent delay as it relates to an impact of the critical path and either relief of liquidated damages or success in achieving a compensable delay claim and getting damages paid to the contractor by the owner. Concurrent delay really does require forensic delay analysis. There can be different things going on in the project that may appear just purely on the face of the schedule or the timing of certain events as concurrent critical path delay. But there's a concept called pacing. So if there is an owner impact to the project, the contractor may elect to slow down or pause or pace its other non-critical works to that owner delay because either it doesn't make sense efficiently to hurry up and wait. They might have materials sitting out exposed to weather for too long. There can be many reasons why a contractor chooses to pace its work to match that employer delay instead of trying to keep up its own activities. And it will appear that it's concurrent delay, and I'll show that on the next slide. But really, that not ready for the next slide yet. Sorry. But really, it's not driving the critical path. The owner delay impact is what we would call the dominant or driving delay impact. What's really important about pacing delays, if a contractor is going to pursue that argument after the fact, in my experience, it's very important that the contemporaneous project record is clear and that the contractor is reporting and informing the owner that it is electing to pace its works. Because if that isn't there, then oftentimes it will be viewed as an after the fact argument to try to get out of liquidated damages, or the owner saying, well, your concurrent delay precludes you from compensable delay. So that an owner can get out of paying for delays if the contractor can't prove that pacing was actually what was being done and not just contractor caused delay on its own. The but-for, or what's called offsetting delay, is what Emily talked about. I see it more commonly in the US, in my experience at least, but it's non-critical delays that are happening in parallel with critical path delays being offset to say, yes, I'll pay you for just the difference in what your delay was and what my delay is. even though the contractor's delay could be days, weeks, months, hundreds of days off of the critical path, and that delay has no impact on project completion. So that's, again, a very hotly debated topic. I think this is a whole nother topic for another webinar, but those non-critical delays do exist, and those would fall under a loss of productivity or disruption damages bucket. So there are costs associated with those non-critical path delays, but they're not pertinent to the extension of time and compensable delay, which is a different set of damages. Next slide, please. And I'm going to try and use this laser pointer function. I don't know if it'll work, but I guess it doesn't really work. Okay, so I have several scenarios here. On scenario 1, there's a critical path on the bottom shown in red to project completion. At the top, you have an employer delay shown in orange, and that is what is affecting the critical path. You also have in blue contractor delay on non-critical path works. In this scenario, I would say there is no concurrency. The owner delay is the only delay to the critical path. So as long as the contract allows, you would get excusable and compensable delay. In scenario 2, now that contractor delay is also impacting the critical path works. This is the example of that rare true concurrency where the 2 delays are happening at the same time. The only time you may see something like this really is at the very beginning of a project when the employer has to give site access and the contractor has to obtain permits, and those are both being delayed for the same or very close to the same amount of time. Scenario 3 moves into the concept of pacing and timing of delay. So another debate in concurrency is which delay happened first. Was the full impact of that delay known at the start of the impact? There's a lot of different factors you have to take into account. So in scenario 3, the contractor delay, which started after the employer event delay started, could be the contractor pacing. Or it could be that these 2 are concurrent for the overlapped period. Scenarios 4 and 5 talk about those 2 delays starting and or finishing at different points in time, both impacting the critical path. So again, there could be potential concurrency for that overlapped kind of hatched period of time, but you would have to do a detailed analysis of what the project record showed, what all of the schedule updates during that period were showing as far as what was being reported and projected pertaining to those 2 delays. And it does oftentimes require expert opinion based on experience in order to determine whether this is actual concurrent delay or whether one of those 2 delays is the dominant driving delay.
So in the interest of time, I do want to note that there are differences between common law and civil law perspectives of concurrent delay. But I want to move on to working with the experts, because this is an important part of the discussion. So Matilde, when is it advisable to start working with an expert?
I think it's advisable to start working with your experts early. So while the lawyers are working to either prepare their claim analysis or prepare their defense, and definitely before the first round of written submissions is filed. I think the more familiar the expert is with the factual background and project documents, the better his opinion and report will be. And also when you're preparing a case, your experts can actually help you identify gaps in the factual record that may need to be filled by witness statements, for example, or provide insight that may impact your legal submissions. And also, I think working with your experts can help you ensure that there's alignment between what the lawyers are saying and what the experts are saying. And the earlier you start working together, the better aligned you are. And this just allows for the experts to agree and fully support the theory and strategy that the lawyers are putting forward.
And so what information do you typically give to an expert to have them be able to make their assessment?
So the key data is the project records, and this is where the importance of good record keeping during the performance of the contract cannot be emphasized enough. Because it is difficult to know when you're in the construction project which events will actually end up being claims in an arbitration. And so the best way to ensure that the documents necessary to support your claim or defense are available is to establish a strong record-keeping practice from the early stages of the project. And also for the experts, and Meera will be able to comment more on this later, it is critical that they can rely on contemporaneous project documentation in formulating the report. When experts are forced to piece together claims and filling large gaps because of inadequate records, the reports are more easily subject to attack for lack of factual support. So good project records also help in preparing credible and high quality expert testimony.
Most definitely. And Emily, what role is the lawyer in working with an expert?
So I think what's really key is that the lawyer works ahead of the expert. So obviously, while a delay expert is needed to opine on the critical path and quantify the extent of the critical delay, the construction lawyer's role is to suggest key issues for investigation based on their understanding of the project, and to also identify helpful documents and witnesses of fact. And also to control the flow of information that goes to the delay expert and to sanity check everything that the expert then does. In terms of identifying the root cause of critical delay, there's a debate as to whether this is the expert's role or if this is the lawyer's role. And really, fact witness evidence should ideally prove precise cause of delay, and it may even require additional non-delay expert evidence on technical matters. But sometimes delays have multiple causes, and it's difficult to determine a precise cause of delay and attribute responsibility. And this is obviously particularly problematic in jurisdictions with a ban on global claims. But I think it's safe to say that identifying cause and responsibility for delay therefore requires careful presentation, language, and evidence from the lawyers.
Thank you. So now we have the information is being given to the expert and the lawyer's role in sort of guiding the expert. And Meera, what is the role then of the expert in performing the delay analysis? And have you ever been asked to do more than what your role is?
Well, to answer answering the second one first, yes, and I'll come to that. So, in my view, an independent delay expert is assessing what the critical path through the work is, identifying all of the causes of delay, potential causes of delay that could affect that critical path, and then quantifying how much each individual cause of delay, to the extent possible, in as so far as many days. So how many days did cause one affect the critical path, cause two, so on and so forth. As Emily said, there's kind of a place where a delay expert's scope of opinion ends, and it kind of shifts over into now the lawyer's realm to interpret the contract, to interpret, is that cause of delay claimable under the contract? Who's liable for that cause of delay? That is really becomes outside of the delay expert's scope of opinion. And as Emily said, there's other technical experts. So if you have design issues, you might need a standard of care expert. If you have structural steel failure, you might need to have a technical structural steel expert. Delay experts can't really possess all of those, and typically are not lawyers either who are trying this case. So it's important for an expert to stay in their lane. I have absolutely been asked and pressed by lawyers, none on this panel, but to go outside of my area of expertise, both on the legal contractual interpretation, so to start opining on liability, as well as to go outside of the delay realm into more technical or design standard of care opinions. And that's where it's really important for the expert to be open and honest with the legal team and say, look, you need to have other experts for this. Here's how much I can say. And I try to do that very early on. Typically in these cases, the delay analysis is done earlier on, damages follows. But if you identify that you need a structural steel expert early on, you need to start communicating that to your client and your legal team right away, so that they have the opportunity to build up that case and get the opinions that they need for that cause of delay. And so, you want to please your client all the time, and I have been asked and pressured, but really it's important to know where your limits are.
Of course, the lawyer needs to be more responsible of what they need to do. Okay, so working with the experts, that's really, really helpful information. So now we want to move on to one really interesting topic that we discussed in organizing this panel is what is the future of delay analysis with AI? So Meera, how do you think AI can help with the delay analysis, if at
Well,
all?
without trying to put myself out of a job, AI is just, I think it's in its infancy, especially as it comes to construction and delay analysis. I think in real construction, it's a little bit more advanced. But the things that I'm seeing, and this will move very quickly, I think, I'm seeing on-site and off-site applications of this. So, when you talk about on-site and actual construction on the project, AI, I think, is further along with the use of drones and robots and modeling and the ability to capture without human error as-built information, progress data on daily, even hourly, even by the minute basis of how a project is being executed. And that will help to avoid the fights over when were certain things done. I mean, that is part of what delay experts struggle with sometimes, is even recreating an as-built of a project. And so, you see that again, there are technology coming out to help with execution of certain activities from a safety standpoint. I just was in another conference, and one of a major contractor player in the global industry did a study that said safety KPIs and safety factors is directly related to delays on a project. And their study of all of their projects for, I don't know how many past years, linked safety and delay impacts in a way that they spoke very strongly about. And so I think if you can use AI also to prevent safety problems, you may actually mitigate some of your delay risk. In the offsite, or in the kind of scheduling world, delay analysis world, project controls world, there are programs being developed that are going to take all that drone information or those 3D modeling snapshot information and pull it into programs that can, again, in almost daily or however often you want to do it, start to predict schedule risks and identify early on the areas for potential mitigation and run scenarios about what could be happening with your schedule in real time. And that's really going to, I guess, hopefully prevent delays, and then also impact delay analysis, because that's additional information that an expert could rely upon after the fact. I think, again, these programs, as I understand it, are really in the early stages of development. So it's going to be fascinating to see how it evolves over the next 5 to 10 years.
Yes, most definitely. And so Matilde, what if the data used isn't reliable? The AI is given data to do something, and the data is incorrect or not correct, or
Yeah, I think everyone here is familiar with the saying "garbage in, garbage out." So I think this point relates to the importance of the project records that I just discussed. The AI tool will be as good as the input data that you fit to it. So the quality of the contemporaneous record, and in general, the quality of the good record keeping practices, are equally important, even if you have a very sophisticated AI tool, I think.
I mean, that goes the same with, giving the information to the delay expert. If they're not given good information, then they can't do their work properly. So Emily, will AI eliminate human involvement in delay analysis? Are we all out of a job?
Well, obviously, that's a really difficult question, and we'd all like to think that we won't be out of the job in 5 to 10 years' time. But I guess there are essentially 2 trains of thought here. So there are those that are in the yes camp, who might argue that AI provides a much faster and more efficient interpretation of the data. And this is because AI has the ability to rapidly organize the data, to process complicated inputs, and produce technical results within seconds. So obviously, that means a lot of tasks previously requiring human involvement would now be done by AI. So AI would, I guess, in essence, replace humans in some of the more repetitive tasks, although these would probably be more administrative based. Because I think it's fair to say that human involvement would still be required on how to interpret and communicate the results produced by AI. Obviously, there are those in the no camp, and they would argue that given the complexity involved in AI and delay analysis itself, human involvement will always be required to explain and interpret the data and make it more transparent for clients and individuals to understand. And it's this human element that will allow one to rely on and trust the actual delay analysis. And actually, any predictions made from AI would still require the knowledge and experience of delay analysts like Meera, who need to use their expertise to pinpoint what data should actually be inputted. And again, that goes to the point that Matilde was making, rubbish in, rubbish out. So I think it's fair to say that human involvement is necessary to kickstart the analysis in the first place. And obviously it goes without saying, but a delay analyst like Meera will always be needed to testify and explain the results in court or at hearings. And AI will only really assist with the repetitive and time-consuming tasks. So where do I stand? What are my own personal views on this? Well, I don't believe that AI will eliminate all human involvement, but I think it will make certain aspects of delay analysis a lot more efficient and a lot faster. But I think in the meantime, humans and AI are going to need to coexist in the field of delay to provide clients and to produce an expert analysis that is clear and accurate and transparent and detailed. But for now, I think AI is going to have to start small. There's not been all that much advancement and specialism in the AI field for delay analysis quite yet. So I think that complex construction cases will still require a large element of human involvement.
Yeah,
And we also need to
go ahead.
I guess another point to consider is if institutions and clients are actually willing to accept delay analysis produced by AI and not delay experts who have had, numerous years worth of experience out in the field. So there's a lot to consider. But I think it's safe to say that our jobs remain safe for now, at least.
Yeah, no, I think you're right that there is a working in conjunction with each other, and some of the maybe you could say mundane tasks could be done by AI, and the human would us would be doing the more difficult heavy lifting, the analysis of everything with the human eye to it. So thank you everyone for presenting today. I think it was a really engaging discussion and really informative. So thank you again. So I want to open up the floor to questions. There were a few questions that were dropped into the chat. Let's see.
So if there's time, there's a question on liquidated damages that I would like to just take a couple of minutes to address. Is that okay with you, Giorgio?
Yes, of course.
So,
go ahead.
So I just think Ricardo Urdaneta in the chat box provided a very interesting question. I think he asked, or he mentioned that I referred to liquidated damages exclusively as remedies in favor of the employer. And I think you're absolutely right that in my presentation, I focused on liquidated damages as payable to the employer if the contractor fails to meet the contractual completion date. But it is true that there may be cases where monetary compensation is actually payable to the contractor. In my experience, however, in delay claims, rather than this being paid as liquidated damages to the contractor, they are categorized as what Meera referred to at the beginning of her presentation as excusable or compensable delay. So this is when the contractor gets both an extension of time and compensation for the extra cost incurred due to that extension of time. And typically what this covered, rather than this being assessed as a liquidated damages or as a fixed sum of money, is it covers the direct costs or the actual cost that the cost for the additional time and expense incurred as a result of this extension of time. I hope that answers your question.
I speaking on behalf of him, I think that was a good answer. So we do have one final question from Orlando Cabrera.
I can see, sorry, there's one on concurrent delay that I think might be worth just talking about. So please do excuse my pronunciation of your name if this is incorrect, but Sumia Sharma has asked a question, and he said, I want to know how the delay claim will be granted / treated by the court / tribunal in the case of concurrent delay. The proportionate claim will be granted or wholly rejected because there is a delay by the contractor. Now, unfortunately, because of time, we kind of rushed through the end of our presentation on concurrent delay, so we didn't quite get to discuss this particular issue. But I think it's definitely something that hopefully everyone on this webinar might think is quite interesting. But obviously, there's various different approaches that exist to concurrent delay depending on the applicable law. So, for example, some jurisdictions may require determination of a dominant cause of delay. So they're looking at, whichever is the greater delay, whereas other jurisdictions may prefer some form of apportionment of the extension of time and associated prolongation costs. So just to give a very quick example here, if a period of concurrent delay is apportioned by the court or the tribunal in a 50-50 split, it would mean that the contractor would only get half the extension of time and associated prolongation costs. So hopefully that gives a bit more flavor to how the treatment of concurrent delay is depending on the applicable law.
Yeah, thank you so much, Emily, for that. So there was one other question, and then we'll close. Hoping that we can keep doing similar webinars on construction law. So as I mentioned in the introduction, that this is the fourth part of the final part of the series on construction law. But I believe the ICDR Y&I has been doing these for the past couple of years. And so hopefully next year we'll continue doing it in another 4-part series. And of course, we'll keep everyone updated on that. So with that, thank you again, everyone, for attending. And thank you again for the panelists. I really, really appreciate all of your time and dedication to this. And I look forward to working with you all again. Thank you.
And thank you, Giorgio.
Thank you for having us.
Thank you so much.